Is the media not allowed in President Trump's D.C. criminal trial on election interference? Federal Prosecutor Jack Smith opposes having media in the courtroom for President Trump's D.C. criminal trial on alleged election interference. Why is he opposing media coverage? And what does the Constitution say about it?
I'm constitutional attorney Catherine Henry. For more than 20 years, I've been fighting for the underdog. But since COVID began, I've devoted all my time and efforts to fighting against government tyranny and educating and empowering the public. So welcome to our next episode of Restore Freedom Weekly.
A coalition of media organizations and NBC have made requests to be able to broadcast the upcoming trial for President Trump on the alleged election interference matters for Washington, D.C. Now, Trump's attorneys agree with the request, but it's Prosecutor Jack Smith who opposes the request. In his objection that he filed in court just a few days ago, Special Federal Prosecutor Jack Smith argues that Federal Rule of Criminal Procedure 53 prohibits the use of media or broadcasting in the courtroom. So what does Federal Rule of Criminal Procedure 53 actually say? It is titled Courtroom Photographing and Broadcasting Prohibited. And it's a pretty short court rule, saying that except as otherwise provided by a statute or these rules, the court must not permit the taking of photographs in the courtroom during judicial proceedings or the broadcasting of judicial proceedings from the courtroom. Now, first of all, let's point out that this court rule literally only stops two things. One, that you can't take photography, you can't take still photos in the courtroom. And two, that you can't live broadcast from the courtroom. But by the literal reading of this court rule, it doesn't prohibit video recording and then a later broadcasting of portions of the trial. But Federal Prosecutor Jack Smith is arguing that it does. But not only do we need to look at the actual wording of this rule, we need to look at something a bit more important. You've guessed it, the Constitution. Now, let's first take a look at Article 6 of the Constitution. And it says, the U.S. Constitution is the supreme law of the land, and all government officials are bound by oath or affirmation to defend and protect it. So, what does that mean? It literally means that no court rules can ever supersede or contradict the Constitution. So let's look at the Constitution. Is there anything in the Constitution that says that the media can be there? That says that the criminal defendant, in this case President Donald Trump, has a right to press coverage of the trial? Well, let's take a look. We need to go no further than the First Amendment to find one of our answers. The First Amendment protects not only the freedom of speech, but the freedom of the press. So this includes not only the right of the press itself to be present and to record and share information to the public, but it also includes the element of the right of the people to be able to watch over government actions. This is akin to the right to attend legislative committee hearings or Department of Education meetings. The people have the right to be able to utilize media and broadcasting as a way of keeping a watchful eye over the happenings of government. So the First Amendment covers the right of the people and the right of the press. But what's also an important right to consider? Well, that would be the right of the criminal defendant, in this case, President Donald Trump. And for that, let's look at the Sixth Amendment to the U.S. Constitution. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Now, how can President Trump's trial be public if the media is kept out? It can't. The bottom line is that we, the people, retain ultimate control and authority via our Republican form of government, guaranteed by Article 4, Section 4 of the U.S. Constitution. We have the authority to oversee all functions of our government, and the accused has the right to be protected by that public oversight. So, no amount of policy that Jack Smith might argue in his briefs, no matter how reasoned it might seem, may override these constitutional guarantees. So although federal court rules, and perhaps even the judge in this case, might agree with federal prosecutor Jack Smith that the media is not allowed to be in the courtroom for President Trump's election interference trial in Washington, D.C. The Constitution very clearly says otherwise.
Want to interact on this important topic? Comment on this video or call in the second Tuesday of the month at noon Eastern Standard Time to participate in our live constitutional discussion. Make sure to like, follow, subscribe, and share. And remember, together we can restore freedom.